Right, good evening. My name is Ferdinand Kehrhahn. I am a lecturer at the University of Pretoria, and I've been asked to do a short presentation on the Mafisa judgment, which is a constitutional court judgment. It's been reported in volume 4 of the South African Law Reports. So let me briefly start with the facts of this case. The plaintiff in this instance suffered damages in a motor vehicle collision and subsequently instituted action in the Bloemfontein High Court. The matter on the day of the hearing or shortly thereafter became settled, and the judge, Justice Deniso, was approaching chambers with a consent draft order and requested to make the draft order an order of court. And the judge then reserved the judgment. Of course, the judge had access to documents in the court file, including the medical legal report, and the court subsequently handed down judgment and dismissed the claim for loss of earnings. So the draft order that was handed up made provision for, amongst others, general damages and loss of earnings, and the court just simply deleted the loss of earnings agreement. Now, the judge not once asked the parties whether they would like to make submissions to the court, whether they would like to present any evidence, or in fact did not even convey contentions with the parties in the matter. The court then, in her judgment, said that she had a problem with the loss of earnings. She couldn't establish how the loss was determined or tendered because there was absolutely no proof of the plaintiff's income. So obviously the plaintiff endeavored or attempted to appeal the matter. The court dismissed the leave to appeal application. A petition to the SCA was subsequently dismissed, and then also a reconsideration application to the SCA dismissed, and eventually the Constitutional Court agreed to hear the matter and granted the plaintiff leave to appeal. Now, let me perhaps just pause here. It is a cause for concern that the appellate, the Court of Appeal don't accept meritorious leave to appeal applications. This matter was a sitter of an appeal, and on all accounts should have been leave to appeal should have been granted without more. But I think the main problem is that the SCA is overworked, and unless it's a matter that is quite a contentious issue, or amounts to a judgment in rem, the SCA often refuse leave to appeal when they should not. This is, for me as a legal practitioner, a cause for concern, and it's something that I increasingly notice. Be that as it may, as I said, the matter then went to the Constitutional Court, and what the Constitutional Court in effect had to consider, the legal question before the court, was whether the the trial judge has the necessary jurisdiction to interfere with a settlement agreement, and whether the court can, instead of granting the order as requested jointly by the parties, whether the court can replace that with an actual judgment. And that was the main issue before the court. Of course, this issue had in the past also been considered by the Constitutional Court in Eek versus Parsons, where the majority of the court held that a settlement brings an end to a dispute. The matter then becomes res judicata. But of course, that does not mean that the agreement that was reached between the parties must be made an order of court. Instead, the court may have regard to the settlement agreement or the proposed draft order, and if it's inappropriate, the court can simply refuse to grant the settlement refused to make the settlement agreement an order of court. Now, when will it be inappropriate? Well, in 3 instances was held in EEC. The first is when the settlement does not relate, there's no relations to the pleading. It's not the case that was made out in the pleadings, or if it's inconsistent with the law, the constitution, or public policy. And finally, if there's no practical or legitimate advantage, for instance, when the point is moot or of mere academic nature. So the court may then insist that the parties resolve the contentious issue or the problem that the court may have before making the proposed draft order and order of court. Now, back to the Mafisa matter. In that matter, it was argued that the court never once had regard to any evidence, and of course that offends the Theodosio matter, where the court said that the court quo must call for evidence, and also the Matwai matter, where Judge Kathy Satchwell was criticized by the SCA for making decisions based on documents in the court file, but which is not evidence. The Constitutional Court said that in this instance, the court quo offended the plaintiff's right to be heard. Instead of communicating with the plaintiff that she had a problem with the draft order and allowing the parties to make submissions on the agreement and or affording the parties an opportunity, she went further than what the parties put before the court and made a ruling on the merits and quantum portion of the claim without affording the parties an opportunity to present any evidence. The court does not have jurisdiction to consider the quantum of the claim. The only issue that was before the court at that stage was the appropriateness of the order, and that was the only issue. The constitutional issues that was before the court was that of equality, Section 9 of the Constitution. Of course, all animals are equal, but some are more equal than others. And the plaintiff, Mafisa, in this matter, complained that the court treats state organs as special litigants. They look after the affairs of the state organs, and they don't treat the parties that appear before them in the same light. And of course, that offends the separation of powers. It's not for the court to step into the shoes of the executive or into the shoes of any state organ to guard the funds. That's not the purpose of the court. It's perhaps just as a footnote, the Justice Fisher from the Johannesburg High Court, in an interview before the Judicial Service Commission, I think she applied for a position on the Competition Appeal Court, said to the committee that the RAF has fired their panel attorneys. They don't pitch up at court. And the judge, that is Justice Fisher, now fights in the corner of the RAF. Of course, if a court makes that concession that they step into the shoes of a state organ, that's a serious cause for concern. Also, the human rights, that is directly linked to equality, and of course also the right to a fair hearing, which is Section 34. If you are not granted the opportunity to be heard and your case is simply dismissed, or at least the loss of earnings component thereof, that must surely offend your right, your constitutional right to a fair hearing, and that's exactly what the Constitutional Court held. Something that the Constitutional Court did not specifically deal with was the right to social security. And you know from other Constitutional Court judgments, such as Law Society, the court held that one of the ways in which the state realized their obligation to ensure social security is by legislation such as the Road Accident Fund legislation. So, of course, an argument could also have been made out that offended the right to social security. But as I said, that was not something that featured before the court in the Mafisa matter. The court had regard, this is now the Constitutional Court, to the purpose of a settlement, and the purpose is to bring the litigation to an end. The issues between the parties becomes res judicata, it avoids further litigation, and of course it creates a new cause of action in line with the settlement. The court cannot be a party to that settlement agreement, and the court can also not enforce the parties to enter into a specific contractual arrangement. The court is then also bound by the issues that is placed before the court. The court can't go beyond the issues that is put before that. So if the merits and the quantum component is not placed before the court, and the court is not asked to make any determination in respect of either of those issues, it would be improper for the court to do so. The Constitutional Court said that parties have a contractual freedom and the court may not generally interfere with the terms of a settlement agreement. The court was mindful of the fact that both parties have a risk in litigation. The RAF may go to court and secure an order lower than the amount offered or settled upon, whereas the plaintiff can go to court and secure a judgment for an amount much higher than the agreed or the settled amount. That's a risk that both parties take. And of course, there's a number of factors that parties may take into consideration. Sometimes it's much cheaper for a party to just simply settle a matter as opposed to running 4 or 5 day trial. Sometimes they may not wish to discover certain documents or be obliged to have their matters ventilated in open court. There can be all sorts of factors that is factored into a settlement agreement and that moves a litigant to settle a matter, and often those issues are privileged and the court may not be privy to that information. It serves the administration of justice best if parties can reach an amicable settlement in litigation. They don't take up any court time, and the Constitutional Court said that the enforcement of the contractual terms cannot depend on the sense of fairness and reasonable of a single judge. That will cause absolute uncertainty and chaos, because even when a party managed to settle an action, the matter is never really settled until it is endorsed by the court. So if the law were to be that a judge may interfere with a settlement agreement without more, it will always be necessary for a litigant to still be completely ready to proceed to trial in case the court is not content with a settlement agreement. And the Apex Court, of course, said that generally the court may not interfere. Right. If a court is then concerned with the settlement because there was fraud, the claim is inflated, the amount exceeds the amount claimed, or it's inconsistent with the law or the Constitution, or it's not consistent with the pleadings, then and in that event, the court can do one of two things. Either the court can refuse to make the order and raise the concern, whatever it may be, with the party, and the parties should be granted an opportunity to then address the issues. And if the court is satisfied, the court can then grant the order, or if the court is not satisfied, the parties can then present evidence and the court can then adjudicate the matter on the evidence. Or the matter can simply be removed from the court's role. The court can do nothing, and the parties can perform privately in terms of their inter partes arrangement. Of course, then the one party won't have the benefit to enforce the order, the judgment creditor. But those are the two options. But here's the catch. A judge, when considering the propriety or the impropriety of a settlement agreement, is not entitled to have regard to inadmissible evidence. And quite, well, more often than not, there won't be any evidence before the court because the matter became settled. And the Constitutional Court said that a quid quo relied on inadmissible evidence. They relied on expert reports, which were simply that, expert reports, and it was not elevated to evidence before the court. And the Constitutional Court held that that was improper and irregular. The appeal court then upheld the appeal and made the draft order, which was put before the quid quo, an order of court. This is truly a remarkable judgment. It's most certainly done a lot of favors to plaintiff and defendants alike, because the court was interfering with court orders on a regular basis. You don't need to read far to find examples of courts simply without more interfering into the parties' agreements. Well, and that is it from my side. Thank you for listening to this, and goodbye.